Okay, welcome everybody. As we already know, we are in week 7 of our 12 weeks legislative drafting training, and today is day 34 of the training, being the 4th day of the 7th week. And this week we have been dealing with miscellaneous provisions. As for one of the parts or structures of a bill. We have discussed preliminary provision, we have discussed principal provisions, and this week we have been discussing miscellaneous provisions. We said that the word, you can check the in-call messages. We said that the word miscellaneous takes its origin or root from Latin. And the Latin word miscere simply means mix up, more like an assemblage of things from different sources. And we also say that the primary purpose of miscellaneous provisions is to ensure the effective implementation of what you have drafted in your principal provision, which is the main thrust of the act or the bill. So miscellaneous provision is so important. If you do not have them, you might find it difficult to fully implement the act or the bill that has been drafted when it becomes an act. You might find it difficult because miscellaneous provisions deals with important clauses or important items such as jurisdiction, where you have a law that there is no defined jurisdiction of either court to sit over it or prosecutory powers assigned to specific agency, you leave so much room for assumption. In legislative drafting, there is no room for assumption. So we talk certainty. There is no room for ambiguity. Whatever we are doing, if it is Mr. A that has responsibility, the law should be written in such a way that it is clear that this is the responsibility of Mr. A. If it is Mr. B that has responsibility, the law should be certain. A miscellaneous provision also deals with items such as powers of entry and search, that is warrants, seizure, powers to arrest, powers to make subordinate legislation, licensing and registration, powers to even inspect. So you discover that miscellaneous provision is so important that without it, you will certainly have an incomplete bill or an act that will be difficult, if not impossible, to fully implement. And what will be the challenge? It will bring up the challenge of going back to amend. You know, when we talk amendments, we think it is all about the legislature reconvening and passing or amending the bill, amending the bill. But it is taking time, it is taking resources, and the time that the legislature would have used to do something else, the resources that the government would have plowed into doing something else, the time of the honorable courts, the time of the parties involved. So it is not just about, okay, if there is any lacuna, why is there room for amendments, they will amend. No. It also tells on the lack of proficiency or excellence of the drafter. So we urge us all to take notes. The reason why our timetable is structured the way it is so that we spend 1 full week repeating the same topic, such that by the end of the day, you would have become one with that topic. So we say that miscellaneous provision is from the word miscellaneous. That's a Latin word, miscellaneous, which comes from miscellus. Miscellus is miscellus, meaning mixed, to mix something together. The word miscellus may have come from misculus. Misculus is misculus, which is the presumed base of the vulgar Latin verb misculare, meaning to mix, mix, to mix. Now, misculare is misculare. Now, because it's not English, there are some hyphenation on the A has a hyphen on top of it. Then etymology, that's the roots. Miscellaneous is made up of miscellus and the adjective suffix enus. Enus, A, then hyphen on top of it, neus. The suffix enus may have come from collectenus, which means to assemble from various sources. Miscre, miscer, which means mix up. Now, if you notice the nature of clauses in miscellaneous provisions, you see that we are talking jurisdiction, we are talking power to make subsidiary legislation mixed up. We are talking notices. We are talking offenses mixed up. We are talking procedure for appeal. We are talking licensing and registration mixed up. It's a mixture of different things.
Hello, Ebenezer.
To ensure the proper implementation of the offense. Sir? Hello, Prof.
Your line went off for some time.
Oh, sorry about that. Subheadings under miscellaneous provisions are as follows. Offenses and provisions ancillary to offenses, such as time limits for prosecution. Continuing offenses, offenses by corporations and vicarious liability. Miscellaneous and supplementary provisions, such as evidentiary provisions. Power to make subordinate legislation or subsidiary legislations or regulations, subsidiary regulations. Service of notices, whether it is notice for meeting.
Ebenezer, my hand is up. My hand is up.
You may proceed, sir.
All right, so let's take it one by one. You can't just read all these things. As drafters, we said we want to make a distinction between a mechanic and an automobile engineer. Both of them can repair a car. The difference is that the engineer knows the inner workings. For each of these sub units of miscellaneous provision, you must know how this operates in real life, not just a theory. That's what makes you an engineer in drafting. So, for example, number one, time limit. There's always, as lawyers or law graduates, you know that for every general rule, there may be exceptions. So this affects the way you draft. For example, the general rule for prosecution of criminal offenses is what? 7 years. That's the statute of limitation. If you don't bring a prosecution within 7 years, then you are barred from your statute barred from bringing prosecution. However, there is an exception. Nigeria is signatory to certain international conventions, such as the ICC, International Criminal Court. So, because we are signatories to these international criminal conventions, one of the exceptions is if a crime is against humanity, if it's defined as a crime against humanity, there is no statute of limitation that can stop prosecution. So, for example, if you read the news, those of you in Nigeria, the former military head of state of Nigeria he did a book launch 20th of February. He made some confessions in the book launch. Based on those confessions, a senior advocate of Nigeria, Femi Falana, is now filing a criminal prosecution against him for acts committed 32 years ago, 1993, on the grounds that Nigeria is signatory to this international convention. So, for crimes against humanity, not all crimes, for crimes against humanity, there is no statute of limitation. You can prosecute no matter, even if it's 100 years. If you have read the news too, recently, a senior advocate of Nigeria has also sued the British government for crimes committed during the massacre of coal miners in Enugu, 1949. So there's no statute of limitation to prosecution for those kind of offenses. So when, as a drafter, you're drafting, when you draft the general rule as your first subsection or section, under it, there are exceptions, notwithstanding the provisions of section 1 above. Prosecution for crimes against humanity shall have no time limit. That's how you draft. So you must know the general rules and then the exceptions when you are drafting. Ebenezer, carry on.
Thank you, Prof. Thank you very much, sir. Another example for limitation, I mentioned that yesterday. If you are bringing a medical negligence case or patient's rights violation case, you can bring that case within 3 years period. However, once 3 years elapses and you have not filed, no matter how strong your claim is, you are out of time, meaning you can no longer bring that claim. Number 2 is power to make, number 3, power to make subsidiary power to make subsidiary legislations here is that you confer power on the head of the agency you have created or a commission you have created through your bill to make further laws, Now, that law is called subsidiary legislation because the act you're drafting is the principal or primary legislation. So the law that the head of the agency is going to make is subordinate to the principal act or to the establishment act. Now, why do we need to confer this power? Because as human, you do not know tomorrow. You as a drafter, you cannot possibly fathom every obstacle that might come up against that law tomorrow. So in the course of implementing the law, anything that is now seen as a stumbling block towards effective implementation of the law, the law has already empowered the head of the agency to make subsidiary legislations to ensure the full implementation of the law. So it will now be a huge negligence on your part as a drafter to, to draft an act establishing a commission or an agency and you omit the power to make subsidiary legislation. Now, why is this power important? Because the business of lawmaking is primarily the responsibility of the legislature. But for purpose of speed, you do not have the time to go back to the legislature to begin to enact maybe one line, two lines as events of vote or occurs, you run back to the legislature. There are some of these things that need just one sentence pronouncement, two sentences pronouncement, directives. For us in practice, the CJ of each state has a power.
Ebenezer, what is CJ? Don't forget your audience is not only Nigerian lawyers.
The chief judge of each state, it is embedded in the rules of each state that the chief judge has the right to make practice directive or practice direction or subsidiary regulation to effective implementation of the rules of court. Last time I showed us the rule that we start. Okay, I just came back from court. The rule I was using today, a colleague looked at it, he said, is this 2025 rule? I said, no, it's still 2024. He said, but it will expire tomorrow. From Saturday, 1st of March, the 2025 rule becomes effective. Now, if there are things that come up tomorrow, the chief judge already has the power to sit in his office and make rules to further the implementation of the 2025 rules. So please, if you are drafting, ensure that this clause is part of your miscellaneous provisions. Then we talked about also notices, be it notice of meeting for statutory corporations. How do you convene meetings? How many days notice before a meeting holds? Who has the responsibility to issue such notices? Now, as you're drafting, you don't just draft and leave out the details. So all these things must be parts. That same statutory corporation, if there is a lawsuit against them, what's the procedure for bringing a lawsuit? You have to include pre-action notice. You do not just say any lawyer or any person who intends to institute a legal action against this corporation must first serve them pre-action notice. What is the duration? Is it 2 weeks? Is it 1 month? So you put it there, usually 3 months in most cases. So you put it there expressly. Then we talked about also powers of entry, search warrants, and arrest. Yes, it is the responsibility of the police to do so, but how should they do so? When you are conferring such power on citizens, on what grounds should that be done? Reasonable suspicion. What is reasonable suspicion? So all these details have to be part of your drafting so that you do not cause confusion where a neighbor will wake up and just call police or just bundle his neighbor to the police station and now claim he has reasonable suspicion. What is your definition of reasonable suspicion? Then we talked about licensing and registration. It is not enough to just say create a need for registration or create a need for licensing. Which office is responsible for issuing the license? What is the mode of applying for that license? How many days, how many months? What's the timeline the license ought to be produced, all things being equal. Such that anybody who is denied application can know whether he's justly denied or unjustly denied. Now, where the person is unjustly denied application, what is the mode of seeking redress? What is the mode of appeal? So you also have to include this in your draft. That's where an applicant feels that he has been unjustly denied his license or registration, such applicants could follow ABC steps to seek redress, or then to what other authority is that person appealing to. The authority has to be specified. Like I said earlier, there is no room for assumption. Then we talked about inspection issues. If you are applying for maybe, okay, for example, we have an agency here called NAFDAC. NAFDAC is National Agency for Food and Drugs, regulating our drugs, standardization of drugs, the chemical composition of drugs, even locally manufactured drinks, whether it is beverage or what, but once it is being consumed, NAFDAC needs to certify it up to our bottled water and sachet water here. If you are applying for now, one of their procedure, there is they are supposed to come and inspect your premises where you are doing your manufacturing. If you are applying for such inspection, what is the procedure? How many days should your application wait? What are the requirements to meet before you call them to come and inspect? So you do not just build a factory and then you call them to come and inspect. Now, all those tiny details, the essence of this detailing is to eliminate confusion, one, to eliminate ambiguity, two, but most importantly, to achieve certainty, to achieve standardization across board, so that when Mr. A is treated this way, Mr. B should be treated in that same way. If there is a deviation, one of the parties who feels dissatisfied can now seek redress following the already laid down procedure here. So this shows how important miscellaneous. For offenses, you spell the offenses out, one. Then ancillary provisions to those offenses, we have already talked about the time. Vicarious liability for corporations, where an employee of a corporate body violates the law or commits an offense, who is liable? Are there exceptions to the vicarious liability? What if the offense is committed outside the work hours? What if the offense is committed, let's assume he's a driver of an agency and he now uses his personal car to commit an offense, not the official car of the agency? Will the agency still be vicariously liable? These are things you spell out here so that there will be no confusion. Any question, please? Okay, Mr. Oscar, ask your question. Yes, I can hear you. line is breaking. There's a background noise coming from your end. Okay. Okay. Sorry, Prof's hand is raised.
Mr. Oscar, I appreciate you. Your background may not help you. When we say at the end of 5 years of study at the university, you are awarded a degree called LLB. In Latin, it means a Bachelor of Laws. The correct pronunciation is Bachelor of Laws. Do you know what that means? That means you have mastered laws so much before you can be awarded that degree. And when we started, those that started this course, we said initially there were no rules and conventions for drafting. Every lawyer used to do his own style. So what you are telling us, Mr. Oscar, is we should go back to any lawyer should draft. You can bring preliminary, miscellaneous, add it to principal. This is your personal opinion, but if you go to our charts, you will see the first book written on legislative drafting, 1902, by a man called Henry Tring. He was the first legislative drafting lawyer of the UK government. He gave us 5 rules. I'm a lecturer. One of the projects I'm supervising on masters in legislative drafting, a student wrote on the 5 rules of the structure of legislation. Henry Tring sat down and said, this is how legislation should be structured. Principal provision, miscellaneous provision, final provision, preliminary. Each should have its own. He said preliminary should come first, principal second, miscellaneous third, final. So the students wrote on this structure of legislation. It was not there before. Lawyers used to write anyhow before 1869. Now you want to take us back to it before 1869. After these principles have been laid down that this is how you should structure these things, now you're telling us no, we should do it the other way. That's why we took out time, a whole day, the history of legislative drafting. When you understand this, what Henry Tring gave us, we have improved upon it, and this is where we are now. Now you're telling us go back to before 1869, which was causing chaos. That is why the parliamentarians said, no, we don't want this law, every lawyer writing the way he likes.
Thank you, Prof. Thank you, Prof. Any other question, please? Any other question? Any other question? Okay, in the absence of any question, I will ask my own question. Let me look at those who have not really contributed this week. I'm going to ask them question. Lekaka, this question is for you. Mention at least 6 clauses that should be under miscellaneous provisions. At least 6. And explain 3. Mention at least 6 clauses that should be under miscellaneous provision and explain 3 of those clauses. Yes, Lekaka, we are waiting. Joyce, the same question goes to you. Mention at least 6 clauses that should be under miscellaneous provision and explain 3. Now, don't be afraid of failing.
Okay,
But
Ebenezer.
yes, do your best to attempt it. If you do not get it right, we correct you.
Okay, thank you. We talked about limitation of actions clause.
Sorry, I didn't get that.
We talked about limitation of actions clause under miscellaneous provisions.
Yes. Limitation of action clause.
Yes. And or should I explain before I go to the others?
Choose, you mention them, then you choose the 3 you want to explain to us. You have given us 1, we have 5 more to go.
Okay. And then we have a jurisdiction clause. We also have licenses and registration clause.
3.
We have vicarious liability clause.
4.
We have appeals clause. Procedures to appeal decisions of the agency.
Okay.
We have offenses clause.
Okay.
And lastly, we have meetings clause. Is it meetings or notices?
Notices.
Notices, yes, notices. Thank you. Notices clause. So we said the clause under, in fact, now coming to explain 3. Did you say I should explain 3 of them, right?
Explain any 3.
Any 3. Okay, that limitation of actions clause, we said it should stipulate time limits for bringing actions. And you gave us an example of what we call in our law prescription, that some actions should be brought before court within a certain period of time. Yes, that is the example that you gave us.
Okay. Okay.
So jurisdiction, it was said that it's a clause. Can I say it was explained as a prosecuting authority. If I got that, yes. And then this other clause, the notices clause, in fact, vicarious liability clause, it states or it provides for where an employee of an agency commits an offense, then it should be clear as to who should be liable for that offense.
Yes.
Yes, and thank you, Ebenezer. I think I have attempted the 3 questions.
Thank you very much. Thank you very much. Okay. Who else can explain the other 3? Who else can explain the other 3? You can, this thing is legislative drafting. You can only know it by doing. If you think you know it in your head or you understood what we said, you'll be shocked at what will happen when, after some time or after having never attempted any, you want to draft. You'll be so surprised at how much you will struggle to remember what we have said. So it can only be part of you when you are part of it. And how can you be part of it? By attempting questions. Yes, by attempting, making attempts, making efforts. Yes, Prof, sir.
Yes, following up from what Ebenezer is saying, I gave you a bill. It's called the Widowhood Leave Bill. The purpose of that bill was the spouses of widows, they were to take 28 days leave after the death of their spouse. They go away from work for 28 days. So the drafters of that bill, you could tell, is not a professionally drafted bill. I gave you that bill because when you work on such a bill, you are improving your drafting skills. I told you that some preliminary provisions were not there, some principal provisions. So your duty was to add those missing elements. And the starting point for such a bill is the arrangement of clauses. Remember, the arrangement of clauses is that part of a bill that is the equivalent of table of contents. So ideally, you should deal with arrangement of clauses before you even go start drafting. So now that we are studying under preliminary, we have subunits. How you deal with that is you go to the widowhood bill. After you check the preliminary. Preliminary has 7 portions, 7 subsets. So under your arrangement of clauses, you check, do I have the long title? Do we have commencement? Do we have application? 7. If you don't have up to 7 parts of the preliminary, then you do that. You add it, you make it 7. You go to principal. Under principal, that widowhood bill, the drafters made a mistake. They created an agency called regulatory agency. However, they did not provide the administrative provisions. Remember, once you create a statutory corporation, then admin provisions have to be there. But if a law does not create an agency, then you do not have administrative provisions. So what do you do when you now know that this bill creates an agency? You now go to your table of contents, which is arrangement of clauses. Then you add the 7, admin provisions are more than, we saw section 3 to 30. That is what? 27 sections. So you add them before you even start drafting the section. Deal with your table of contents because that will help you. Then you go to miscellaneous provisions. This widowhood bill does not require a lot of miscellaneous provisions like licensing, because it is not a law creating a licensing scheme. But you may have subsidiary legislation, you may have other things, but not licensing. So you put that, the portions of miscellaneous provisions that will be required, you put it in your table of contents, which is arrangement of clauses. By the time you have dealt with your arrangement of clauses, it will make it easier for you when you start drafting the sections. So this is how you deal with. I gave you that deliberately so that you use it to practice. Use it to practice and improve your drafting skills. Because most of you did the assignment you sent to me, I noticed that the arrangement of sections were not there. That is why you missed out the provisions you ought to add. So in law, we say these are the tricks of the trade. These are things you cannot see them in textbooks. The textbook by Vincent Crabbe. Vincent Crabbe is late. You cannot meet him to explain most of these things. The textbook by Taunton, which is an authority in legislative drafting. Taunton is an Australian lawyer. He's also late. So we are here to explain these things to you. And now we need you to grasp, have a good understanding of legislative drafting, the principles, the conventions, because we're even moving further. We are now moving away from paper drafting to technology, the use of technology in drafting. I've posted online, I think it's March 14th, this Brazilian group, they have a training by the US House of Reps, the Office of Legislative Counsel. The head of that office will tell us how they use technology in legislative drafting. You cannot grasp this lecture if you do not have a basic understanding of the components of legislative drafting. So it's important you grasp this first before you now move on to technology, the use of technology in drafting. Because if you understand the concepts very well, when technology is introduced to you, you now know how to place them. All right, thank you.
Thank you very much, Prof. And with that professorial admonition, we have come to the end of today's class. By tomorrow, the assignment for the week will be out. Once again, I encourage us to try, attempt it. Just try your hands. Attempt it. Thank you very much.
Thank you, Ebenezer.
Thank you.